But here we are back right before the start of this second phase of that civil trial. And you've seen fit to email the judge and say, I want to intervene as a separate party or represented separately from both the NRA and the New York Attorney General's office, because you don't feel like either one of them are representing you or NRA members correctly.
Yes.
Why is that?
Well, when I watched the run up to this second phase of the trial, looking at the court documents filed by both parties, nobody was talking about what's called the 715B violation for whistleblower. And so I had to do a lot of research with that. And it was something that was rather frustrating, because as we got through the election and we went to the board meeting in May at the annual meeting in Dallas, and then I went to the new board member orientation in June, it became clear to me that they have no intention of correcting their past behavior. I wanted to give them the benefit of the doubt. I hope that the jury, which spoke loud and clear, gave them the direction they should have gone, and they have definitely decided not to. Charles Cotton is at the heart of all of this problems with NRA. He was president for 3 years. He was acting president for another couple of years, because Carolyn Meadows seldom went to the board meeting because of health reasons, although she was at the last one. And he's at the heart of all of it. And President Barr, that was the one race we didn't win. We were running Owen Buzz Mills for president. That's the only race we really lost that mattered. And he has still not appointed any of us to committee, except today he just appointed Rocky to audit committee. But all the other committee slots that are the 5 committees that he decided today, the rest of us didn't get any so far. I'll probably be on range development again, or youth programs or something that's not working, because they don't have the money to make it work. Anyway, it became clear to me that they were going to run an ethics complaint on me, like they did back in the 90s on some of the board members, to get them off the board, and then get me booted off the board by that process. And as long as those people who are intent on continuing to punish me as a whistleblower are there, I'm always going to be at risk, and they will continue their abuse without restriction. As soon as this case is over, I'm sure my life changes on the board.
Okay. So, because we had you on a couple of weeks back, right? After the elections, the leadership elections, and
yes,
3 of the 4 top leadership positions were filled by reformers, other than the president position, as you just mentioned there.
Yes.
And you seem pretty optimistic at that point. But you're saying now that your outlook on that has changed so much that you feel the need to intervene in this case and hope to get a sort of third way option for the judge. Is that what your goal is?
Okay. So as I understand it, with the research that I've done, there's not a specific statute that gives me a right to cause of action, but there are New York cases that say there should be a private right, because so employees can bring it. And I think so it should also be for board members to bring it. And so we'll see what the judge says about that. The reality is that that's really not high on the Attorney General's list of things they'd like to accomplish in this trial. Their number one goal is to get that financial monitor in place. And that seems to be about all they were arguing about until about a week ago, after I filed my motion. Some filings have been filed by the New York Attorney General that gave me some hope that they would be in my corner on this topic, because if they do not fix this culture of corruption inside, they're just going to end up back in court in a year or 2 with the same problems, assuming NRA survives that long.
Right. And I do want to get to some of the things the AG is recommending as part of her filings for the second phase of this trial. But first, let's talk a little bit more about I guess the internal dynamics going on at the NRA and why you felt the need to take this particular path, right? So one complaint, as you mentioned, is the lack of committee appointments for you and the other reformers. The 4 for Reform was, you guys ran on the 4 different candidates. Rocky Marshall is part of that. He has been appointed to the finance committee, but the rest of you, the other three,
audit. He got on.
Oh, sorry, audit.
Yeah.
The other,
should be on
the other
finance.
three of you haven't. And additionally, you've been highly critical of former President Cotton. He's on almost every key committee from audit to ethics to finance at this point, right?
That's correct.
And that's a big part of it. But there's also a handful of other complaints that I think you had mentioned that you're in the email you sent, the letter you sent to the judge. You claim that the Special Litigation Committee, which controls, I guess, the legal strategy for this case and other cases related to the NRA, NRA's administration, that you didn't think the new members of leadership had been swapped out with the old members of that committee. Can you explain that a little bit?
Okay. So the Special Litigation Committee is a committee that's created by the board. It did not say how members of the committee would be removed or replaced in that resolution. So they defer to the bylaws, which says that the president has the power to appoint and create committees, even though this was a board committee. And I think that's a flawed analysis because it's a board created committee. It named 3 people to it. It takes board action to change who makes up the committee, which I don't believe has happened even when I was gone. I got all 3 board books, the minutes from the 3 board meetings I missed because I wasn't on the board, and reviewed them. And I still haven't found a resolution that changes the membership of that committee. So in theory right now, it's apparent that they are operating as if Bob Barr has complete control over who's on that committee. And it's him and Cotton and one other that are now on SLC. I want to say Coy, but I'm not 100% certain on that. They pulled Willis Lee off when he wouldn't go on board with some crazy plan they had. And he got kicked off the committee and put to the back bench, and he wasn't very happy about that, but Cotton did that for him. I think that it's pretty clear that the board should be able to fix that the board members and the officers should recognize that this is a new day, that with the outstanding results of the election, that we honestly have the members' mandate. And there's no doubt in my mind that if we did not have the SLC and Brewer attorneys on our running this case, that we could probably settle the New York AG case, just like we settled the one with the Washington, D.C. Attorney General and the NRA Foundation. And that would save millions, because Brewer's going to bill us every minute of that $1,400 an hour he charges, which I think is ridiculous too. And, we're going to be upside down, I'm afraid, very soon.